Welcome back to the Deep Dive, where we unpack complex ideas into fascinating, actionable insights. Today, we're diving into one of the most fundamental, yet often misunderstood, areas of criminal law. The general exceptions and defenses laid out in India's new Bhartiya Nyaya Sanhita 2023, or BNS 2023. We're talking about the bedrock principles that determine when an act, even one that causes harm, isn't considered an offense in the eyes of the law. It's about understanding the deep legal thinking that shapes these provisions.
That's right. These sections are more than just legal minutiae. They are the very scaffolding of criminal jurisprudence. They meticulously define the boundaries of criminal liability, ensuring that justice is truly served and only those with a genuine culpability are punished. Our mission today is to thoroughly explore the nature, object, scope, application, and the rich legal juristical approach behind sections 14 through 44 of the BNS. We'll be navigating everything from acts done under legal duty and pure accident to the complexities of consent and the critical right of private defense.
It's like uncovering the legal system's built-in safety valves, or those rare get-out-of-jail-free cards. But as you'll discover, they come with incredibly stringent rules and conditions. You'll leave this deep dive with a much clearer understanding of why some actions that appear to be offenses are actually legally sanctioned, and the intricate, sometimes surprising philosophy behind it all. So let's unpack this crucial aspect of the BNS. Hashtag Part 1, the foundations of excused duty, justification, and good faith. Sections 14-17. Let's kick things off with a foundational concept. When someone commits an act that looks like an offense, but they were actually bound by law to do it or genuinely believe they were. Section 14 of the BNS 2023 addresses act done by legal compulsion or mistake of fact. So what's the core idea here? Protecting individuals acting under actual or perceived legal compulsion.
It's a crucial starting point. The core concept is really about protecting individuals who are either fulfilling a direct legal obligation or who, through an honest, good faith mistake about the facts, genuinely believe they are bound by law to perform an act. The legal system recognizes that we can't punish people for doing their duty, nor should we punish them for a diligent error in understanding a factual situation.
Right.
The object here is dual. First, it ensures that public servants, like police or military personnel, can carry out their duties without fear of criminal prosecution for lawful actions. Second, it provides a safety net for ordinary citizens who might, under a bona fide mistake of fact, act under a perceived legal compulsion. This is vital for maintaining public order and, crucially, trust in law enforcement.
That makes a lot of sense. So for this defense to apply, what are the key elements, the basic ingredients, if you will, that must be present?
Okay, for this protection to be invoked, we look for two main scenarios. First, the person is actually bound by law to do the act. That's pretty straightforward. Performing a recognized legal duty. Second, and this is more nuanced, the person believes themselves to be bound by law. However, this belief isn't enough on its own. It must arise from a mistake of fact, not a mistake of law. If you mistakenly believe a law exists that doesn't, or that a law applies to you when it doesn't, that's generally not excusable.
Okay. That distinction is key.
Absolutely. And critically, this belief must be held in good faith. The BNS in Section 211 defines good faith as doing something with due care and attention. So a reckless or negligent mistake won't offer protection. It implies a genuine, diligent effort to ascertain the facts.
The distinction between a mistake of fact and a mistake of law sounds really important. Can you give us a couple of illustrative scenarios to make that clear? The outline mentions a soldier and a court officer.
Certainly. Take the classic illustration. A soldier fires on a mob under lawful orders from a superior, acting in conformity with the law. In this instance, the soldier commits no offense because they are actually bound by law to follow lawful orders to maintain public order. This clearly demonstrates legal compulsion.
Right, straightforward duty.
Now, for a mistake of fact. Imagine a court officer ordered to arrest Y. After conducting a thorough inquiry, the officer arrests Z, genuinely believing Z to be Y. Here, the officer is protected because their belief, though mistaken, arose from a mistake of fact, the identity of the person, and was held in good faith.
Meaning they did their homework, basically. They showed due care.
Exactly. They exercised due care and attention in their inquiry.
That's a great clarification. So what's the broader nature and scope of this section?
Its nature is primarily excusatory. It doesn't mean the act was inherently right, but it negates criminal liability. It does this by showing either that the accused was performing a lawful duty or lacked the necessary criminal intent, mens rea, due to a bona fide factual error.
So it excuses the act rather than justifying it.
Precisely. The scope is quite broad. covering acts performed under actual legal obligation and those under a good faith mistake of fact regarding such an obligation. The key distinguishing feature, as we discussed, is the critical difference between an excusable mistake of fact and a generally inexcusable mistake of law. This distinction is rooted in that foundational legal maxim.
Oh, the Latin one, ignorantia something.
Ignorantia facti excusat. Ignorantia juris non excusat. Ignorance of fact excuses, ignorance of law does not excuse. This maxim is absolutely central here. It underlines that while the law makes allowances for factual errors made with diligence, it expects everyone to know the law of the land. It's a cornerstone of any legal system.
How have courts interpreted this principle historically before the BNS came into effect? What did they look for under the old IPC Section 76?
Well, courts consistently looked at whether the believed facts, if they had been true, would have indeed made the act lawful or compulsory. The determination of good faith is always a factual inquiry, examining the prudence and diligence exercised by the accused. It's not a blanket excuse for carelessness. A critical point from jurisprudence is that while the soldier illustration protects following lawful orders, orders from a superior officer are not a defense if they are manifestly illegal. The law expects discernment. A patently unlawful order cannot be blindly followed and then excused. The order must conform to law, as in our soldier illustration.
That really clarifies how the law protects those following duties. Now, building on this idea of shielding individuals who act in the state's interest, the BNS dedicates specific provisions to our judiciary. Section 15 talks about the act of judge when acting judicially. What's the fundamental principle behind this, ensuring judges can operate without fear?
This is about the doctrine of judicial immunity, a globally recognized principle. The core concept is absolute immunity for judges from criminal prosecution for acts performed within their judicial capacity. The object here is paramount, to ensure the absolute independence and fearlessness of the judiciary.
So they can make tough calls without worrying about being prosecuted themselves.
Exactly. Judges must be able to make difficult, often unpopular decisions without the constant apprehension of facing criminal charges themselves. This is vital for the impartial and effective administration of justice, protecting the very integrity of the judicial process.
And what are the key ingredients for this kind of protection? What needs to be established?
Firstly, the act must be performed by a judge, as defined explicitly in BNS Section 216. Secondly, and critically, the judge must be acting judicially at the time. This distinguishes official judicial duties like hearing a case, passing an order, or sentencing from private or purely administrative acts.
Okay, so not everything a judge does is covered.
Correct. Thirdly, the act must be in the exercise of a power actually given by law. Or, one, the judge genuinely believes in good faith to be given by law. So, even if a judge makes a good faith mistake about their jurisdiction in a particular matter, they are still protected. The good faith, again, refers to due care and attention.
This sounds like very strong, almost absolute protection. What's its nature and scope?
It is indeed an absolute immunity for acts performed within their judicial capacity. Its scope is quite broad, covering not only acts strictly within jurisdiction, but also those where a judge might, in good faith, mistakenly believe they have jurisdiction. This reinforces the principle of actus curiae neminem gravabit. An act of the court shall prejudice no one.
How does protecting the judge help ensure the court doesn't prejudice anyone?
Well, by protecting judges, the law ensures that their decisions are unbiased and that the legal system itself isn't undermined by fear. This ultimately benefits everyone who comes before the court. Previous jurisprudence under IPC Section 77 confirms that this immunity is for judicial capacity, distinguishing it from purely administrative acts unless they are intrinsically linked. However, the protection, while broad, is not limitless. If malice or corruption can be unequivocally proven, or if the act is clearly outside the scope of acting judicially, the claim to immunity could be challenged, but this is an exceptionally high bar.
Following up on the judiciary, Section 16 deals with acts done pursuant to judgment or order of court. This seems to protect those who carry out court orders, like bailiffs or police. Is that the idea?
That's precisely right. The core concept here is about shielding individuals, typically court officers, law enforcement, or even a citizen acting under a court's directive, who are simply executing judgments or orders issued by a court. The object is straightforward: to ensure that judicial mandates are carried out effectively and without hesitation by protecting the executors from criminal liability.
Even if the court made a mistake.
Yes, this protection is so vital that it extends even if the court's order is later found to be jurisdictionally defective, so long as the executor acted in good faith, believing the court had the authority to issue that order. It upholds the authority and finality of court judgments.
So the person carrying out the order isn't expected to second-guess the court's jurisdiction every time. They just have to act in good faith.
Not if they act with due care and attention, which is what good faith implies here. The basic ingredients are: the act must be done in pursuance of or warranted by a court judgment or order, and it must be done while that order is in force. Crucially, the protection still applies even if the court lacked jurisdiction, provided the person executing the act believed in good faith that the court had the necessary jurisdiction.
Okay, so it's an excusatory provision again.
Yes, it's excusatory, and it upholds the principle of res judicata pro veritate capiter. A judicial decision is taken as truth for the purposes of those executing it. However, if an order is patently or manifestly illegal, or from a court so obviously lacking jurisdiction that a reasonable person could not believe it had authority, then the protection might not stand.
Because that would negate the good faith belief.
Exactly. It wouldn't demonstrate due care and attention. It's primarily about protecting ministerial acts performed under proper authority.
That's a very practical protection for those upholding the judicial system. Finally, in this part, Section 17, act done by legal justification or mistake of fact believing justified. How does this differ from Section 14, which we started with? Section 14 was about being bound by law.
Exactly. While Section 14 focused on being bound by law to perform an act, Section 17 pivots to being justified by law, or genuinely believing oneself to be justified due to a mistake of fact. Justification implies a legal right or permission to act in a certain way, even if it causes harm. Think acting in self-defense, using lawful force to prevent a crime, or making a citizen's arrest.
So it's about having a right to act rather than a duty.
Precisely. The object is to excuse acts that are either legally sanctioned or performed under an honest, reasonable misapprehension of facts that, if true, would have provided such legal justification. This empowers citizens to act in certain circumstances to uphold law and order or protect themselves within carefully defined boundaries.
So the basic ingredients are quite similar to Section 14. You're either actually justified by law, or you believe yourself justified due to a mistake of fact, not law, and in good faith. Is that right?
Correct. The ingredients mirror Section 14 in structure, emphasizing the mistake of fact over a mistake of law and the necessity of good faith, due care, and attention. Consider the illustration. A sees Z apparently commit murder, and A seizes Z to bring them before the authorities. Even if Z was actually acting in self-defense and committed no offense, A commits no offense. Why? Because A was acting under a good faith mistake of fact, believing Z had committed murder, and was legally justified in making a citizen's arrest under that belief.
That perfectly illustrates the concept. What's the nature and scope of this provision then? Still excusatory.
Yes, its nature is also excusatory, negating criminal liability. The scope covers genuinely justified acts and those performed under a good faith mistake of fact regarding justification. It consistently excludes a mistake of law, reinforcing ignorantio juris non excusat. This section essentially codifies the doctrine of justification, recognizing that some acts, despite causing harm, are legally sanctioned due to overriding principles. Pre-BNS interpretations under IPC Section 79 require that the believed facts must have legally justified the act, and any force used must be proportionate to that believed justification. Good faith requires a genuine belief and due care, not rashness or negligence.
Hashtag part 2. Excuses based on incapacity and unforeseen events, Sections 1824. That's a deep dive into duty and justification. Now, moving beyond legal obligations, the BNS also acknowledges that life is full of unpredictable moments, accidents, emergencies, or situations where individuals might not fully comprehend their actions. This next set of provisions, starting with Section 18, delves into these unforeseen events and states of incapacity. So for a truly unavoidable oops moment, like an accident during a lawful act, how does the law differentiate it from a criminal offense in Section 18, accident in doing a lawful act?
This section covers those unfortunate oops moments, as you put it, but with very strict qualifiers. The core concept is clear: no criminal liability for pure accident or misfortune. When an individual is engaged in a perfectly lawful activity, in a lawful manner, by lawful means, and crucially, with proper care and caution.
Right, that last part sounds critical.
It is. The law is designed to punish intentional wrongdoing or culpable negligence. Its object is to excuse unforeseen, unintended harm because true criminal law operates on the principle of actus non facit reum nisi mens. Sit and act does not make one guilty unless there is a guilty mind. A genuine accident inherently lacks that guilty mind.
So it's not enough for something just to be unexpected. What are all those stringent conditions that need to be met for this defense to apply?
Indeed, for this excusatory provision to apply, all 6 basic ingredients must be meticulously met. Firstly, the result must be an accident or misfortune. Secondly, without any criminal intention or knowledge. Thirdly, during a lawful act. Fourthly, done in a lawful manner. Fifthly, by lawful means. And finally, and this is often the linchpin, it must be done with proper care and caution.
All 6. If anyone is missing, the defense fails.
Exactly. Particularly the requirement of proper care and caution. If that's not fulfilled, the defense will fail, and the individual might then face charges for negligence or rashness.
Can you give us a classic example of this? The outline mentions a hatchet.
Certainly. Imagine A is working with a hatchet, properly and carefully, splitting wood in a designated area. Suddenly, the head of the hatchet flies off unexpectedly, striking and killing a bystander. If A exercised proper caution, meaning they were using the tool correctly, it was in good condition, they were alert to their surroundings, then A commits no offense. The death, in this context, is a pure accident or misfortune.
But if they were being careless?
Right. If A was using a faulty hatchet they knew was dangerous or was swinging it recklessly in a crowded space, then the proper care and caution ingredient would be missing and the defense would collapse.
That proper care and caution truly is the linchpin then. What does that phrase mean in practice? How is it judged?
It refers to the standard of care that a reasonable and prudent person would exercise under similar circumstances. It's an objective test. The nature of this provision is excusatory because it negates the criminal intent or culpability usually required. Its scope is narrowly circumscribed precisely because all conditions must be fulfilled. The absence of mens rea is central here. Previous jurisprudence under the analogous IPC Section 80 indicates that while the prosecution bears the overall burden of proving guilt, the burden of raising the defense of accident by demonstrating these elements typically rests with the accused on a balance of probabilities.
And what counts as proper care can change depending on the situation.
Absolutely. What constitutes proper care can vary. For instance, a highly dangerous activity demands a higher degree of care than a mundane one. This section is all about distinguishing a true, blameless accident from actions that are rash or culpably negligent.
Now, Section 19 introduces what's known as the doctrine of necessity, acting to prevent a greater harm. This sounds like a profound moral and legal dilemma codified into law.
It truly is a fascinating area, often called the lesser of two evils principle. The core concept here is that nothing is an offense merely by reason of being done with the knowledge that it is likely to cause harm. If it is done without any criminal intention to cause that specific harm, and crucially, in good faith, for the sole purpose of preventing or avoiding another, greater harm to person or property.
So you know you might cause harm, but you do it anyway to stop something worse.
Exactly. The object is to recognize that in certain compelling dilemmas, actions taken to avert a more significant, imminent catastrophe are not criminally culpable. The law acknowledges that sometimes people are forced into impossible choices where harm is unavoidable, and it focuses on the proportionality of the harm caused versus the harm averted.
So it's not about avoiding any harm, but specifically a greater harm, and the situation has to be dire. What are the ingredients?
Precisely. The basic ingredients are stringent. The act must be done with knowledge that it's likely to cause harm, but crucially, without criminal intention to cause that specific harm. It must be done in good faith again, with due care and attention. The explicit purpose must be to prevent or avoid other, greater harm to a person or property. And the explanation clause clarifies that it's always a question of fact whether the harm to be prevented was of such a nature and so imminent as to justify or excuse the risk.
Imminence and justification. Sounds like a high bar. Can you walk us through some illustrative scenarios? The examples provided are quite dramatic.
They are, and they illustrate the extreme circumstances required. Consider illustration. A ship captain during a storm changes course to avoid hitting a boat with 20-30 passengers, knowing this might cause their ship to hit another boat with only 2 passengers. If the captain acted in good strength to avoid the greater immediate danger, they commit no offense.
Okay, choosing the lesser harm.
Or, illustration B, pulling down houses to prevent a massive conflagration from spreading through a town, thereby saving many more lives and properties. In both cases, harm is known to be likely, but it's done to prevent a far greater imminent harm.
Those are powerful examples, and it seems this defense must have a very narrow scope. It can't be used lightly.
It is indeed a narrowly defined defense, applicable only in compelling circumstances of unavoidable choice. The harm caused must always be proportionate to the harm avoided. This defense is linked to the legal maxim, necessitas non habet legem, necessity knows no law, but modern legal application is highly circumscribed. It's about the lesser of two evils principle.
Is it justificatory or excusatory?
Its nature can be both justificatory and excusatory, depending on the specific context. A significant limitation, however, is that traditionally, necessity has generally not been accepted as a defense for grave crimes like the murder of an innocent person to save oneself.
Like the famous shipwreck case.
Exactly. The English case of R.V. Dudley and Stevens, where shipwrecked sailors resorted to cannibalism, is a stark reminder of these limits. While BNS Section 19 doesn't explicitly list murder as an exclusion, the stringency of the justification test for grave harms would make such an application exceptionally difficult. This defense isn't for mere convenience or economic necessity. It's for sudden, extreme, non-self-created emergencies with no other reasonable alternative.
Let's move to something quite different. Sections 20 and 21, which deal with acts of children, the concept of doli incapax. Section 20 grants absolute immunity to children under 7 years of age.
This is a fundamental principle reflecting deep societal values about childhood. Section 20 provides absolute immunity, stating nothing is an offense which is done by a child under 7 years of age. The core concept is doli incapax, Latin for incapable of forming criminal intent.
Incapable in that.
Right. The object is to completely exclude very young children from the ambit of criminal law, recognizing their developmental inability to understand the true nature and consequences of their actions, let alone form the sophisticated criminal intent, mens rea, required for an offense.
So for a child under 7, there's no question, no inquiry into their understanding no matter what they do. It's just automatic.
None at all. The basic ingredient is simply that the act is done by a child under 7 years of age. Its nature is an absolute and irrebuttable presumption of law. This means it cannot be challenged or disproven. It offers complete immunity, irrespective of the act's nature or consequences. The scope covers all acts. This aligns with the parens patriae doctrine, where the state acts as a benevolent guardian, prioritizing welfare systems over criminal punishment for such young children. Jurisprudence under the analogous IPC, Section 82, consistently upheld this absolute immunity.
But then Section 21 steps in for children between 7 and 12, offering a qualified immunity. This sounds like where the gray areas begin.
This is where it gets really interesting, as the law becomes more nuanced. Section 21 introduces a rebuttable presumption of doli incapax. The core concept is that children in this age group are developing, and while they might understand some aspects of their actions, they might still lack sufficient maturity to judge the criminality or moral wrongfulness of their conduct.
So it's rebuttable, meaning it can be challenged.
Exactly. The object is to provide an exception if they genuinely lack this maturity, recognizing that cognitive development varies among individuals.
So it's not just about their age, but their understanding of the specific act on that particular occasion. That sounds very specific.
Exactly. The basic ingredients are the child is above 7 years of age and under 12 years of age, and they have not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. This, on that occasion, is critical. It's an individualized assessment, not a general statement about their intelligence.
So how does this qualified immunity work?
Its nature is qualified or conditional immunity. It's a rebuttable presumption. This means the prosecution can present evidence to demonstrate the child's maturity, arguing they did understand the criminality. The scope, therefore, focuses intensely on individual maturity, assessing their comprehension of the physical nature, immediate results, and moral legal wrongfulness of that particular conduct at that specific time.
What kind of things would a court look at?
Courts, under the analogous IPC Section 83, would consider a range of factors: the child's intelligence, their education and home background, their behavior before, during, and after the act, and whether they attempted to conceal it to determine if they knew they were doing wrong. The burden of proving this lack of maturity typically falls on the defense.
Now let's explore the complexities of mental state and intoxication with Sections 22, 23, and 24. First, Section 22, act of a person of unsound mind. This is often called the legal insanity defense, and it's something people frequently misunderstand.
You're right, it's a very challenging area of law. The core concept is that a person cannot be held criminally liable if, At the time of the act, due to unsoundness of mind, they were incapable of knowing the nature of the act, or that what they were doing was either wrong or contrary to law.
Incapable of knowing the nature or wrongfulness or illegality.
Correct. The object here is deeply rooted in justice. To exempt those with severe mental defects who lack the fundamental capacity for rational judgment and understanding of wrongdoing. It perfectly aligns with actus non facit reum nisi mens sit rea, without a guilty mind, there should be no criminal act.
So it's about not having that guilty mind due to a specific mental state. What exactly are the stringent conditions for this defense?
The basic ingredients are quite specific. The accused must have been of unsound mind at the time of the act. This is crucial. It's not about a general diagnosis, but their state at the moment of the alleged offense. This unsoundness of mind must then have rendered them incapable of knowing the nature of the act. For example, they didn't know they were stabbing someone, thinking they were cutting an apple. Or incapable of knowing that the act was wrong, morally, or that it was contrary to law, legally. The "or" is disjunctive, so any one of these incapacities will suffice.
And this is an excusatory defense again.
Yes, it's a purely excusatory defense, negating responsibility due to a defect of reason. Its scope is confined strictly to legal insanity, which is distinct from mere medical insanity.
That's an important distinction. Legal versus medical insanity.
Very important. A person might be medically insane, but still capable of knowing the nature and wrongfulness of their act according to the law's standards. The incapacity, therefore, must be cognitive, affecting their understanding, not merely an emotional outburst or an uncontrollable impulse.
And the Omnitin rules are often associated with this defense, right? Can you briefly explain their historical basis and relevance here?
Absolutely. Section 22, like its IPC predecessor, Section 84, is substantially based on the historical Omnitin rules, a landmark English legal precedent from 1843. These rules establish the cognitive test for legal insanity, focusing on the accused's capacity to understand right from wrong concerning the specific act. The underlying theory is furiosus solo furor punitor, a madman is punished by his madness alone.
And how do courts apply this? What's the burden of proof?
Courts, interpreting the analogous IPC Section 84, have consistently drawn that sharp distinction between medical and legal insanity. The burden of proof for this defense is on the accused, to prove their unsoundness of mind on a preponderance of probabilities, meaning it's more likely than not. They examine various factors: the accused's history, their conduct before, during, and after the act, the presence or absence of motive, and expert psychiatric evidence, though expert evidence is never conclusive on its own. Landmark cases like Surendra Mishra v. State of Jharkhand and Harisingan v. State of Madhya Pradesh exemplify the careful and nuanced approach courts take, emphasizing that cognitive incapacity at the time of the act.
Next, Section 23 covers involuntary intoxication. This sounds like a very specific and probably rare scenario.
It is indeed quite specific. The core concept is that criminal responsibility should not attach when an individual's mental faculties are so severely impaired by intoxication that they become incapable of judgment, provided that the intoxication was not self-induced.
So keyword, involuntary.
Absolutely. The object is to excuse individuals whose capacity to understand the nature or wrongfulness of their actions was overcome by an intoxicant administered without their knowledge or against their will. It's an excusatory provision based on the absence of mens rea due to an involuntarily induced state.
So if someone, say, spikes your drink and you then commit an act without understanding what you're doing, you might be protected.
Precisely. The basic ingredients are: the person must be in a state of intoxication at the time of the act, and this intoxication must have rendered them incapable of knowing the nature of the act or that it was wrong, or contrary to law, mirroring the cognitive incapacity test for unsoundness of mind. And the crucial proviso, the intoxicant must have been administered to him without his knowledge or against his will.
What's the scope? Pretty narrow.
Yes, its nature is excusatory, negating intent. Its scope is strictly limited to involuntary intoxication. Mere willingness to consume an intoxicant, even if given by another, doesn't make it involuntary if the person knew it was an intoxicant. Courts, interpreting IPC Section 85, place the burden of proving this on the accused, highlighting that the level of incapacity must be severe equivalent to unsoundness of mind.
Then what about voluntary intoxication and specific intent knowledge in Section 24? This seems to be the more common everyday scenario where someone chooses to get intoxicated.
This section clarifies the legal position for voluntary intoxication, which is far more common. The core concept is that generally, voluntarily getting intoxicated is not an excuse for a criminal act. However, the law distinguishes between knowledge and intent.
Okay, knowledge versus intent. How does that work with intoxication?
For knowledge, a person who doesn't act in a state of intoxication is liable to be dealt with as if they had the same knowledge as they would have had if they had not been intoxicated, unless the intoxication was involuntary under Section 23.
So the law basically says you should have known better, even if you were drunk.
For knowledge, yes. For intent, particularly specific intent, the severity of intoxication can be considered if it was so extreme as to prevent the accused from forming that particular intent required for the specific offense.
So if you choose to get drunk and then break the law, you can't just claim you didn't know what you were doing for knowledge, but maybe for specific intent.
That's the nuance. The object is to prevent self-induced intoxication from becoming an easy escape from liability. The legal maxim, qui peccat ebrius, luet sobrius, let him who sins when drunk be punished when sober, is the general principle. However, its scope acknowledges that while knowledge is generally imputed as if sober, for offenses that require a particular specific intent, example, intent to cause grievous hurt for a specific type of assault, as opposed to just a general intent to act, severe intoxication might prevent the formation of that specific intent.
Can you explain that difference between specific and basic intent a bit more?
Sure. Basic intent usually refers to the intent to commit the physical act itself, like intending to punch someone. Specific intent refers to an ulterior motive or purpose beyond the basic act, like punching someone with a specific intent to cause grievous bodily harm or entering a building with a specific intent to steal. Section 24 allows intoxication to be considered for these specific ulterior intents. The landmark Indian case under IPC Section 86, Basdev v. State of Pepsu, established this. Intoxication could potentially be a defense if it negated the specific intent required for the offense, but knowledge is always presumed as if sober. The degree of intoxication is paramount. Mere drunkenness is insufficient to claim this defense. The burden of proving such incapacity rests on the defense.
##### Part 3. The Nuances of Consent in Benevolent Acts, Sections 25-29. We've covered some complex ground with incapacity. Now let's explore the intriguing and sometimes ethically challenging area of consent. We start with Section 25, act not intended to cause death or grievous hurt, done by consent. This sounds like the legal concept of volenti non fit injuria to one who volunteers, no harm is done.
That's precisely the principle at its core, but it's applied within very strict criminal law limits. The core concept is that an act is not an offense by reason of any harm it may cause to a person above 18 years of age, who has consented to suffer or take the risk of that harm, provided the act was not intended to cause death or grievous hurt, and the doer did not know it was likely to cause such grave harm.
So minor harms are okay if an adult consents, but not serious ones.
Essentially, yes. The object here is to exempt minor harms in consensual situations involving adults, respecting an adult's autonomy and choice to accept certain limited risks.
So, for example, if I'm fencing with a friend for fun and I accidentally hurt them a little, I'm not going to be in trouble if we both agree to the risk.
That's the perfect illustration provided in the BNS itself. A and Z fence for amusement, agreeing to suffer minor harm during the bout. If A fairly hurts Z, A commits no offense. The basic ingredients are stringent. The act must not be intended to cause death or grievous hurt, and the doer must not know it's likely to cause death or grievous hurt. The harm must be to a person above 18 years of age, and that person must have given valid consent, express or implied, to suffer that harm or take the risk.
And this is an excusatory provision.
Yes, it's an excusatory provision, but its scope is strictly limited to harms short of death or grievous hurt. Consent simply cannot justify intentionally causing grave harm. Previous jurisprudence under IPC Section 87 emphasizes that consent must be free, voluntary, and the consenting person must fully understand the implications and the nature of the risk involved. It acknowledges a limited sphere of personal autonomy.
That leads perfectly into Sections 26 and 27, which are about acts done for a person's benefit, with or without guardian consent. Section 26 specifically focuses on act for a person's benefit, with consent not intended to cause death. This is a significant provision, especially in medical contexts, right?
Absolutely. This section protects benevolent acts performed with adult consent, provided there's no intent to cause death. The core concept is to facilitate beneficial actions, most commonly medical treatments, by ensuring that professionals aren't held liable for inherent risks when informed consent is given by the patient. The object is to promote welfare and allow necessary, sometimes risky, interventions for a person's well-being.
So the good faith and the benefit are key here, along with the patient's consent. Can you give us an example, like a risky surgery?
Absolutely. The illustration is a surgeon performing a risky operation, let's say a complex cardiac procedure for a patient's benefit. The surgeon knows the operation is likely to cause death, but has no intention to kill. The patient, above 18, gives their informed consent. In such a scenario, even if the patient unfortunately dies, the surgeon commits no offense.
Okay, what are the essential ingredients there?
The basic ingredients require the act not to be intended to cause death, done for the person's benefit, which, importantly, the explanation to Section 30 clarifies excludes mere pecuniary gain, performed in good faith, with due care and attention, and with the person's express or implied consent to suffer the harm or take the risk.
And it's excusatory again.
Yes, it's an excusatory provision for risks undertaken for a recognized benefit. Under IPC Section 88, courts have meticulously clarified that benefit is not restricted to pecuniary gain but encompasses well-being, and consent must be specific and informed, distinguishing between implied and express consent in medical contexts.
And Section 27 extends this protection for beneficial acts to children and persons of unsound mind who can't consent for themselves. This seems vital for vulnerable individuals.
It truly is a crucial provision for protecting our most vulnerable. Section 27 covers acts done in good faith for the benefit of a child under 12 years of age or a person of unsound mind, by or with the consent of their guardian or lawful charge. The core concept here is the doctrine of substituted consent or guardian's consent.
Substituted consent.
Yes, the object is to ensure these vulnerable individuals receive necessary beneficial treatment, care, or interventions, while simultaneously establishing strict safeguards against abuse. It allows medical and care actions to proceed when the individual themselves lacks the capacity for informed consent.
What kind of strict safeguards are we talking about here? Given the vulnerability of the individuals, this seems open to potential misuse.
The safeguards are indeed stringent and are laid out in 4 critical provisos. The basic ingredients demand that the act be done in good faith, for the benefit of a child under 12 or a person of unsound mind, by or with the consent, express or implied, of their guardian, and that the act would only be an offense by reason of the harm caused. However, the provisos significantly narrow the scope.
Okay, what do the provisos say?
The exception does not extend to intentionally causing death. It also generally does not extend to knowingly causing death, unless it's specifically for the purpose of preventing death or grievous hurt, or curing a grievous disease or infirmity. Similarly, it excludes voluntarily causing grievous hurt unless for preventing death or grievous hurt or curing a grievous disease or infirmity.
So really tight restrictions on causing serious harm, even with guardian consent.
Extremely tight. These stringent provisos, echoing IPC Section 89, reflect the state's parents' patriarchal role, its duty as a guardian to protect those unable to act for themselves. They ensure that substituted consent doesn't become a license for severe harm without overwhelming and life-saving justification. Courts interpret these provisos very strictly.
Next, Sections 28 and 29 really put boundaries around what constitutes valid consent. Section 28 defines when consent is not legally valid. This seems fundamental.
What's absolutely fascinating here is that Section 28 clarifies what nullifies consent, which is crucial for any defense relying on it in the BNS. The core concept is that for consent to be legally valid, it must be genuine, informed, and truly voluntary, free from coercion, fundamental misunderstanding, or incapacity. The object is to ensure that consent as a defense is not abused and is rooted in true agreement.
So my awareness of the other person's state of mind is critical here, right? If I know their consent isn't genuine.
Precisely. Your awareness is key for certain elements. Consent is not valid under 3 primary conditions. A, if it's given under fear of injury or a misconception of fact, and D, the doer knows or has reason to believe that the consent was given under such fear or misconception. Here, the accused's knowledge of the defect in consent is vital.
Okay, fear or misconception plus knowledge by the accused.
B, if it's given by a person who, due to unsoundness of mind or intoxication, is unable to understand the nature and consequence of the act to which they consent. This focuses on the cognitive capacity to comprehend the specific act. C, if it's given by a person under 12 years of age, unless the context of the specific provision says otherwise. This aligns with the Dali Incapax principles we discussed earlier.
So this section basically defines invalid consent.
Yes, it's a definitional and qualifying section, setting negative criteria for consent. It applies to any section of the BNS where consent is a factor for an exception. Previous jurisprudence under IPC Section 90 clarifies that fear of injury must be such that it truly removes the voluntary character of the consent, and misconception of fact must be material to the decision and known to the accused. This section acts as a vital safeguard.
And then Section 29, exclusion of acts, which are offenses independently of harm caused, tells us when consent simply cannot make an act lawful no matter what.
This section acts as a further, very important limitation on consent-based offenses. The core concept is that consent to harm, even if freely given, cannot legitimize an act that is prohibited by law for reasons other than or in addition to the harm caused to the consenting individual.
So if the act itself is illegal for public policy reasons, consent doesn't matter.
Exactly. The object is to uphold public policy and legal prohibitions against per se offenses acts that are inherently illegal or against societal norms regardless of the victim's willingness. The illustration of causing miscarriage is a perfect example. Causing miscarriage, unless for the specific purpose of saving the woman's life under other legal provisions, is an offense regardless of any harm to the woman, and her consent or even your guardian's consent does not justify it.
So how does this work? When do these consent exceptions not apply?
The basic ingredients are that if any of the consent-based offenses under Sections 25, 26, or 27 are invoked, but the act is an offense independently of the harm caused or risked to the consenting person, then those exceptions do not apply. This is a restrictive overriding provision. Its scope applies to acts that are illegal in themselves, mala prohibita or mala in se, for broader societal reasons, beyond merely the harm to an individual. It reflects the powerful legal maxim Privatorum conventio jure publico non derogat. Private agreements cannot derogate from public law. Courts, under IPC Section 91, consistently focus on whether the act remains an offense even without harm to the consenting person.
Hashtag part 4, benevolent intervention and compulsion, Sections 30-32. That's a deep exploration of consent and its limits. Now let's explore more nuanced areas, starting with Section 30. Act done in good faith for benefit of a person without consent. Emergency. This sounds like a legal safety net for true life or death emergencies where you can't get consent.
It absolutely is, and it's a very humanistic provision. The core concept is protecting individuals who act in good faith for another's benefit during emergencies, when obtaining actual consent is either impossible or unavailable, and timely intervention is critical. The object is to allow life-saving or harm-preventing actions to proceed without the fear of criminal liability, recognizing that in dire moments, people need to be able to help without legal repercussions. It reflects a form of implied consent, where actual consent simply cannot be obtained.
The illustrations provided really paint a vivid picture of these kinds of emergencies. A surgeon operating on an unconscious patient, or even something as dramatic as firing at a tiger carrying off a person, knowing it might harm the person, but intending their ultimate benefit. What makes these acts non-offenses?
In all these illustrations, whether it's a surgeon trepanning an unconscious patient to save their life, or performing an emergency operation on a child despite the child's resistance because there's no time to reach the guardian, or even dropping a child from a burning building into a blanket below, the basic ingredients are met. The act must be for benefit, which, importantly, the explanation clarifies, excludes mere pecuniary gain. It must be done in good faith, with due care and attention.
And crucially, without consent, because it's impossible or no guardian is available in time.
Exactly. And crucially, it's done without consent because it's either impossible for the person to signify consent or the person is incapable of giving consent, and there's no guardian or lawful charge from whom timely consent can be obtained. The offense, if any, is only by reason of the harm caused. The nature of this defense is excusatory, akin to a specific application of necessity for another's benefit.
But this must also have some strict provisos, similar to other consent-based sections, given the potential for harm without consent.
Indeed, like Section 27, this section is heavily constrained by 4 strict provisos to prevent misuse. The exception doesn't extend to intentionally causing death. It also generally does not extend to knowingly causing death, unless it's specifically for the purpose of preventing death or grievous hurt or curing a grievous disease or infirmity. Similarly, voluntarily causing grievous hurt is excluded unless it's for preventing death or grievous hurt or curing a grievous disease or infirmity.
Again, very strict limits on serious harm, even in emergencies.
Absolutely. These provisos signify a clear hierarchy of harms, implicitly stating that certain grave harms, particularly intentional death, are rarely justified, even for another's benefit, unless absolutely necessary to prevent an even greater and imminent catastrophe. This principle is underpinned by the legal maxim salus agrotis suprema. The welfare of the patient is the supreme law, but within very tight legal boundaries. Previous jurisprudence under IPC Section 92 emphasizes that the impossibility of obtaining consent and the urgency are factual questions, and the act must be genuinely beneficial based on objective assessment.
Next, Section 31 deals with communication made in good faith. This feels very relevant in today's world where information, even tough or upsetting information, is often necessary for a person's well-being. Maybe telling someone bad news.
It is indeed highly relevant, reflecting a critical aspect of professional ethics and human interaction. The core concept is protecting bona fide communications made for the recipient's welfare, even if those communications unintentionally cause harm, such as emotional distress or even physical shock. The object is to ensure professionals like doctors, counselors, or even concerned family members are not deterred from making truthful, necessary, and difficult communications due to fear of criminal liability for unintended consequences.
The example provided of a surgeon informing a patient of a terminal illness and the patient dying of shock perfectly illustrates this delicate situation.
Yes, that illustration perfectly captures the essence. The basic ingredients are a communication is made, it's done in good faith, meaning with due care and attention and without malicious intent. It's made for the benefit of that person, and harm is caused to the recipient by reason of the communication.
What's the nature and scope here?
The nature of this provision is excusatory. Its scope covers any communication, and the harm can be mental, emotional, or physical. It effectively protects truthful but distressing communication, encouraging necessary disclosures while emphasizing the paramount importance of good faith. This means the communication shouldn't be reckless, malicious, or carelessly delivered. This supports the ethical principle of a duty to inform. Courts, under IPC Section 93, treat good faith and benefit as factual questions and will carefully consider the manner of communication. A callous delivery could negate good faith.
Finally, in this part, Section 32, act compelled by threats, duress. This is often seen in movies where someone is forced to commit a crime under extreme pressure, like a gun to their head.
Yes, this is the classic defense of duress or compulsion, a powerful and often dramatic legal concept. The core concept is that, except for murder and offenses against the state punishable with death, nothing is an offense if it's done by a person who is compelled to do it by threats. That reasonably caused the apprehension that instant death to that person will otherwise be the consequence.
Instant death? That's a very high threshold.
Extremely high. The object is to acknowledge the limits of human resistance when faced with an immediate and overwhelming threat of instant death, recognizing that the accused's free will is overborne by such extreme coercion.
But there are critical exceptions.
Yeah.
Right, you mentioned murder and capital state offenses.
Absolutely. The exclusions are indeed critical. This defense is explicitly not available for murder and offenses against the state punishable with death. This signifies a powerful ethical stance in the law. It expects individuals to choose to die rather than take an innocent life, or commit acts of treason that threaten the very fabric of the state, especially if punishable by death.
So what are the ingredients for duress, besides the exclusions?
The basic ingredients are stringent. The act must be an otherwise offense, compelled by threats, and these threats must reasonably cause the apprehension of instant death to that person.
And what about if you put yourself in that situation? If you willingly get involved with criminals, like joining a gang?
That's covered by a crucial proviso. The person cannot voluntarily, or due to apprehension of a lesser harm, have placed themselves in the situation where they became subject to such constraint. Explanation 1 clearly states that if someone voluntarily joins a gang of dacoits knowing their character, they cannot claim duress if later compelled by their associates to commit a crime. This is because they willingly expose themselves to the risk.
But if you're an innocent bystander forced into it?
Right. Explanation 2 provides a counterexample. A smith seized by dacoits and forced, by threat of instant death, to break open a house is protected. The smith did not voluntarily join the gang. The nature of this defense is excusatory, based on the will being overborne. Its scope is narrow, the threat must be of instant death, and the apprehension must be objectively reasonable. Jurisprudence under IPC Section 94, consistent with English cases like R.V. Howe, emphasizes that the threat must be present, imminent, and extreme, with no reasonable opportunity for escape or protection, and no prior willing exposure to coercion.
#tag Part 5, the right of private defense protecting body and property. Sections 33-44. We've covered a lot of complex ground, and now we move into a particularly impactful and often discussed area, the right of private defense. Let's start with Section 33, act causing slight harm, which sounds almost contradictory to the idea of defending oneself. It's about trivial stuff.
Not contradictory, but rather complementary. Section 33 embodies a very practical and ancient legal maxim. De minimis non curat lex, the law, does not concern itself with trifles. The core concept is that nothing is an offense if it causes harm so slight that no person of ordinary sense and temper would reasonably complain of such harm.
So the law just ignores really minor things.
Exactly. The object is purely pragmatic, to prevent a criminal justice machinery from being bogged down by petty, inconsequential matters, thereby conserving precious judicial resources for more serious cases. This is a complete excusatory defense that acts as a filter.
So if I accidentally brush past someone in a crowded market causing no real injury, that's not an offense. Or if a child takes a tiny piece of candy without asking, that kind of thing.
Precisely. In such scenarios, the harm is genuinely trivial. The basic ingredients are that an act causes, or is intended or known to cause, harm that is so slight that no person of ordinary sense and temper would complain. The ordinary sense and temper test is an objective standard, applied by the courts to assess whether a reasonable person would actually find cause for formal complaint.
What's the scope? Does it apply everywhere?
Its scope covers any offense where the harm is demonstrably trivial. Pre-BNS jurisprudence under IPC Section 95 consistently determines slightness as a question of fact, considering the nature, intent, the relationship between parties, and prevailing social norms. It also clarifies that this defense isn't available if the trivial harm is part of a larger criminal design. It's about recognizing the practical limits of legal intervention.
Now, Section 34 introduces the general principle, things done in private defense. This is where we get into the heart of self-protection, a right people often talk about.
This is a fundamental and inherent right deeply embedded in legal philosophy. The core concept is the legal recognition of an individual's inherent right to protect themselves and their property or that of others from unlawful aggression. The object is to legitimize the use of necessary force to repel an imminent unlawful attack against one's own body or property, or indeed, the body or property of another person.
And you said this is justificatory, not excusatory.
Exactly, that's a critical distinction to grasp. A justificatory defense, like private defense, says, what you did was not wrong at all. It was legally sanctioned and correct under the circumstances. Section 34 serves as this overarching general declaration, and its scope is then meticulously detailed in the subsequent sections from 35 to 44. It's rooted in the primary instinct of self-preservation and the idea that the right arises when state protection isn't immediately available or effective.
What are the basic principles courts look at?
Previous jurisprudence under IPC Section 96 always stresses that it's a defensive right, not retaliatory, commencing with a reasonable apprehension of danger and continuing only as long as that apprehension lasts, with any force used being proportionate to the threat.
And Section 35 specifies what exactly can be defended.
Right, of private defense of body and property. So it's not just about me, right? I can defend others too.
That's right. It extends beyond personal defense. This section defines the specific subjects of the right, establishing its broad ambit. Every person has the right, always subject to the restrictions contained in Section 37. Specifically, you have the right to defend, A, his own body and the body of any other person against any offense affecting the human body. This explicitly extends the right to defend others, invoking what's sometimes called the alter ego principle. Alter ego principle, acting for someone else as they could act for themselves.
Exactly. And B, the property, movable or immovable, of himself or of any other person, but this is limited to specific offenses, against acts which are offenses falling under theft, robbery, mischief, or criminal trespass, or attempts thereof.
So I can defend my neighbor and their property, too, against those specific crimes. That's quite a responsibility.
Yes, it is, and it underscores the communal aspect of security and justice that the law encourages. The object is to clearly define the ambit of this right. Its nature is definitional and empowering, but always conditional and subject to the strict limitations that follow. Courts, under IPC Section 97, have clarified that property defense generally doesn't extend to causing death unless for grave offenses specified later in Section 41.
What if the aggressor isn't criminally liable themselves, like a child or someone of unsound mind, as we discussed earlier? Does the right of private defense still apply? That's Section 36.
This is a crucial clarification that ensures the right of private defense is practically effective. Section 36 states that even when an act, which would otherwise be an offense, is not considered an offense by reason of the aggressor's youth, lack of maturity, unsoundness of mind, intoxication, or misconception of fact, you still have the exact same right of private defense against that act as if it were a full-fledged defense.
So the danger is real, even if the person isn't legally responsible for creating it.
Precisely. The core concept is that the right of private defense applies irrespective of the aggressor's criminal culpability because the physical danger posed by their act is real and immediate, regardless of their mental state or age.
So if an insane person tries to kill me, even though they won't be charged, I can still defend myself as if they were sane and fully culpable.
Exactly. Illustration A makes this clear. If Z, of unsound mind, attempts to murder A, Z commits no offense under the BNS. However, A has the very same right of private defense against Z as A would have if Z were sane. Another example, illustration B. If Z mistakenly attacks A, believing A to be a housebreaker when A is legally entitled to enter, Z commits no offense, but A still has the same right of private defense.
So the focus is on the threat, not the attacker's state of mind.
Exactly. The object is to ensure self-protection. Its nature is clarificatory, focusing on the objective threat posed. This principle prevents a defender from being left defenseless. Pre-BNS jurisprudence on IPC Section 98 affirms this.
Okay, now for the really important restrictions in Section 97. Acts against which there is no right of private defense. This is where the law draws crucial lines, the limitations.
This section is pivotal. It lays down crucial limitations, preventing the right from being misused and ensuring it remains defensive, necessary, and proportionate. The overarching object is to balance an individual's fundamental right to self-protection with the state's authority to maintain public order and to encourage citizens to rely on public authorities whenever possible. It's about ensuring private defense is a last resort.
Let's break down these critical limitations. First, acts by public servants. When don't you have the right against them?
There's no right of private defense against acts done or attempted by a public servant or by their direction, if done in good faith under color of office, even if those acts are not strictly legal, unless those acts reasonably cause apprehension of death or grievous hurt.
So minor irregularities by officials acting in good faith don't trigger the right unless there's a serious threat.
Correct. The rationale is to protect officials performing their duties. However, there are vital caveats in explanations 1 and 2. You are not deprived of your right unless you know or have reason to believe that the person is a public servant or acting under their direction, and, if demanded, the public servant produces their authority or warrant.
And what if there's enough time to call the police or get other help from public authorities?
Clause 1C is crystal clear on this. There is no right of private defense if there is time to have recourse to public authorities. This principle underpins the entire doctrine. Private defense is for immediate necessity and self-preservation when state protection is absent or ineffective, not a substitute for it.
And the amount of harm.
Subsection 2 establishes an absolute prohibition. The right never extends to inflicting more harm than is necessary for the purpose of defense. This is the fundamental principle of proportionality. It's defense, not retribution or revenge.
So necessity, proportionality, and the primacy of state protection are the key takeaways here. That makes sense.
Absolutely. Its nature is one of restrictive conditions, applying universally. It embodies a careful balancing act. Courts, interpreting IPC Section 99, place the onus on the prosecution to demonstrate that these limits apply, once the accused has established a reasonable apprehension of danger. Time to have recourse is a factual question. Color of office implies official capacity. The harm inflicted must never be retaliatory.
Let's get into the gravest circumstances. Section 38. When private defensive body extends to causing death. What kind of threats justify taking a life in self-defense? This is a huge deal.
This is an exceptional and grave provision justifying the ultimate act of defense. The core concept is providing the maximum possible protection when the apprehended danger is of the direst and most life-threatening nature. The right of private defense of the body extends to voluntarily causing death or any other harm to the assailant if the offense occasioning the right falls into one of 7 specifically enumerated descriptions of assault or acts, and is always under the restrictions of Section 37.
What are those 7 specific and serious circumstances that allow for lethal force? Can you list them?
They are: A, an assault that reasonably causes the apprehension of death. B, an assault that reasonably causes the apprehension of grievous hurt. C, an assault with the intention of committing rape. D, an assault with the intention of gratifying unnatural lust. E, an assault with the intention of kidnapping or abducting. F, an assault with the intention of wrongfully confining a person under circumstances that reasonably cause apprehension that they will be unable to have recourse to public authorities for their release. G, And reflecting contemporary societal threats, an act of throwing or administering acid or an attempt to do so which causes a reasonable apprehension that grievous hurt will be the consequence.
Wow, so this is a clear, exhaustive list focusing on the most severe and impactful threats to life, limb, or liberty.
Yes, it's a meticulously enumerated list. Its nature is an exceptional provision justifying homicide, and its scope is strictly limited to these 7 specific types. The reasonable apprehension is paramount. It must be a real or reasonably apparent danger, not mere subjective fear. This provision highlights the principle of necessity of extreme defense, allowing extreme measures in extreme peril. Courts, interpreting IPC Section 100, consistently emphasize that the apprehension must be present and real, assessing the situation from the accused's perspective under stress. But the right is not absolute.
If the threat isn't one of those deadly 7, what then? Section 39. When private defense of body extends to harm other than death, what level of force is okay then?
This section defines the principle of proportionality for less severe bodily threats. The core concept is that if the offense occasioning the right of private defense is not one of the grave descriptions specified in Section 38, then the right of private defense of the body does not extend to voluntarily causing death to the assailant. However, it does extend, subject to the overall restrictions specified in Section 37, to the voluntary causing to the assailant of any harm other than death.
So you can still use force to defend yourself, but you absolutely cannot kill someone over, say, a simple assault or minor hurt.
Precisely. This is about strict proportionality. The object is to permit necessary defensive harm short of lethal force for less severe attacks, while rigorously maintaining the restrictions of Section 37. Its nature defines permissible non-lethal harm. The scope applies to all bodily offenses not meeting the Section 38 threshold. The prohibition on causing death is clear and absolute for these lesser threats, but permission for lesser, proportionate harm is granted. Courts, under IPC Section 101, consistently hold that the harm inflicted must be reasonably necessary for the defense, and exceeding this right can lead to the defender themselves being charged.
How long does this critical right of private defense of the body last? When does it start and stop? Section 40. Commencement and continuance.
This section defines the precise temporal limits of the right, which is crucial for its legitimate application. The core concept is that the right of private defense of the body commences as soon as a reasonable apprehension of danger to the body arises from an attempt or threat to commit the offense. Crucially, the offense need not have been actually committed. The apprehension is enough.
So you don't have to wait to get hit first.
No. And it continues as long as such apprehension of danger to the body continues.
So it's not about waiting to be actually hit. It's about anticipating the danger, and the right lasts only as long as that danger is imminent.
Exactly. The object is to allow preemptive action when danger is imminent and real, and to ensure the defense continues only as long as the immediate threat persists, without becoming an act of retribution. Its nature defines the duration. The trigger is reasonable apprehension, an objective test. This right is purely defensive, not punitive. It ceases the moment the aggressor is disarmed, has retreated, or is otherwise rendered incapable of causing further harm. Pre-BNS jurisprudence under IPC Section 102 emphasizes this.
Now let's apply this to property. Section 41. When private defense of property extends to causing death, again, what are these grave circumstances for property that justify lethal force? When can you use deadly force to protect stuff?
Here, the law acknowledges that some property offenses are committed with such violence or in such circumstances that they inherently pose an imminent threat to persons, thereby justifying lethal force. The core concept is that the right of private defense of property extends to voluntarily causing death or any other harm to the wrongdoer under the restrictions of Section 37 if the offense or attempt is one of 4 specifically enumerated descriptions.
And what are those 4 categories of property offenses where taking a life might be justified?
They are A. Robbery. This offense inherently involves or threatens violence against a person. B. Housebreaking after sunset and before sunrise, commonly known as night housebreaking. The law presumes a heightened danger to inhabitants when a dwelling is broken into at night. C. Mischief by fire or any explosive substance committed on any building, tent, or vessel which is used as a human dwelling or for the custody of property. This poses an obvious life threat. D, and finally, theft, mischief, or house trespass. It's committed under such circumstances as may reasonably cause apprehension that death or grievous hurt will be the consequence to a person.
So for theft, mischief, or general house trespass, it's about whether there's also a direct threat to life or limb, not just the property itself.
Exactly. That's the crucial qualifier for those specific offenses. It directly links property defense to personal safety. For robbery and night housebreaking, the law essentially presumes a higher degree of danger to persons due to the nature of the crime itself. Its nature is an exceptional provision justifying homicide specifically for property offense in these high-threat scenarios. Courts under IPC Section 103 consistently confirm this.
Section 42 then covers when private defense of property extends to harm other than death for less severe property threats.
So the proportionate response again. This section outlines the crucial proportionality rule for property defense where lethal force is not justified. The core concept is that if the offense, or attempt, is theft, mischief, or criminal trespass, but it is not of any of the grave descriptions specified in Section 41, then the right of private defense of property does not extend to voluntarily causing death. However, it does extend, subject to the overall restriction specified in Section 37, to the voluntary causing to the wrongdoer of any harm other than death.
So you can't shoot someone for, say, simple theft of a bicycle, but you can use non-lethal force to stop them, like tackling them.
Precisely. The law unequivocally prioritizes human life over property. The object is to permit necessary defensive harm short of lethal force for these less severe property offenses, while consistently respecting the general restrictions of Section 37. Its nature defines permissible non-lethal harm for common property offenses not covered by Section 41. The prohibition on causing death is absolute here, but permission for lesser proportionate harm is granted. Courts, under IPC Section 104, emphasize reasonableness.
And how long does the right of private defense of property last? Section 43 covers commencement and continuance, with different rules for different offenses. This sounds complicated.
This section provides precise temporal boundaries for the right of private defense of property, which vary depending on the nature of the offense. The core concept is that the right is dynamic and depends entirely on the persistence of the threat or the commission of the offense. The object is to provide clear boundaries, ensuring the right is exercised only when there's an actual continuing threat.
Can you break down the different timelines for us? When does it start and stop for theft versus robbery versus trespass?
Certainly, A. General commencement. The right generally commences as soon as a reasonable apprehension of danger to the property arises. This allows for preemptive action. B. Against theft. It continues until the offender has retreated with the property, or public assistance has been obtained, or the property has been recovered. This allows for a limited hot pursuit.
So you can chase them a bit, but only until you get the stuff back or help arrives.
Essentially, yes. C. Against robbery. This is more intense. It continues as long as the offender causes or attempts to cause death, hurt, or wrongful restraint, or as long as the fear of instant death, instant hurt, or instant wrongful restraint continues. D. Against criminal trespass or mischief. It continues as long as the offender continues in the commission of the offense. So if someone is actively vandalizing your property, the right lasts as long as they're doing it. E. Against night housebreaking. It continues as long as the house trespass begun by that night, housebreaking continues. This recognizes the extended period of vulnerability.
Okay, so it's very specific to the crime.
Yes, its nature defines the lifespan with offense-specific durations. Previous jurisprudence under IPC Section 105 clarifies these points, emphasizing the end of apprehension or the cessation of the offense.
Finally, Section 44 addresses a very specific and dramatic scenario. Private defense against deadly assault with risk to innocent person. This must be incredibly rare but crucially important. What happens when defending yourself risks hurting someone innocent?
It is indeed rare, but absolutely critical for dealing with extreme exigencies. The core concept is that if, in the exercise of the right of private defense against an assault which reasonably causes the apprehension of death, the defender finds themselves in a situation where they cannot effectually exercise that right without risk of harm to an innocent person, then their right of private defense extends to the running of that risk.
So the law allows you to risk harming an innocent person to save your own life from a deadly attack if there's no other way.
Yes, under those extreme circumstances. The object is to recognize that in such life-threatening dilemmas, the law will not hold the defender liable for unintended harm to an innocent bystander while legitimately defending their own life when no other effective option exists.
The illustration given of firing into a murderous mob where children are mingled truly brings home the gravity of this situation.
It perfectly illustrates the extreme exigency. Imagine A is attacked by a mob attempting to murder them. A cannot effectually defend themselves without firing into the mob, and in doing so might harm children mingled with the mob. If A causes harm to any children under these circumstances, A commits no offense. The basic ingredients are exercising private defense against an assault causing apprehension of death, being in a situation where the defender cannot effectually exercise that right without risk of harm to an innocent person.
What's the nature and scope? Very limited, I assume.
Very. The nature is a highly specific excusatory provision for extreme self-preservation. Its scope is limited to deadly assaults where no other effective defense is available, and the risk to the innocent is unintentional. This reflects an extreme form of the doctrine of necessity and the fundamental supremacy of the right to life. Previous jurisprudence under IPC Section 106 states this defense is only available in extreme necessity with no other options, and the harm must be unintentional. The initial aggressor, of course, remains fully liable.
#tag Part 6. Introduction to Abetment, Sections 45-48. Wow, what an incredible journey through the general exceptions and defenses. We've navigated the complex terrain where an act that seems wrong isn't an offense. But the BNS, 2023, also extends its gaze to those who don't commit a crime directly, but rather facilitate or instigate it. This takes us briefly into Chapter 4.
Indeed. While Chapters 3 focus on excuses and justifications for acts that would otherwise be offenses, Chapter 4, specifically Sections 45 through 48, pivots to the principles of abetment. These sections lay the crucial groundwork for understanding how individuals can be held culpable for promoting, aiding, or instigating the commission of an offense, even if they don't directly carry out the primary criminal act themselves.
Expanding the net of responsibility.
Exactly. It's about expanding the net of criminal responsibility beyond just the principal offender.
So this isn't about what you did directly, but how you help someone else do it. This sounds like a fascinating area of complicity.
Precisely. These provisions recognize that criminal responsibility isn't confined solely to the person who pulls the trigger or steals the item. It extends to those who instigate, conspire, or intentionally aid in an unlawful act. The legal maxim, qui facit per alium facit per se, he who acts through another, acts for himself, perfectly encapsulates the spirit of abetment. It's about the various forms of complicity.
Holding those behind the scenes accountable.
Right. These sections are crucial for the comprehensive application of criminal law, ensuring that those who stand behind the scenes, so to speak, are also held accountable.
What are the foundational principles of abetment that these sections introduce? Can you break down the core concept of abetment itself, what an abettor is, and the different ways it can occur?
Okay. The BNS defines abetment as instigating a person to do a thing, engaging in a conspiracy for doing a thing, or intentionally aiding a person to do a thing. An abettor is, quite simply, a person who abets an offense. The core concept is secondary liability, meaning you are held responsible for assisting in someone else's crime.
Secondary liability. And the ways it happens. Instigation, conspiracy, aid.
We typically look at three main modes of abetment. 1. Instigation, Section 45. This is about actively provoking, inciting, or encouraging someone to commit an offense. It requires a mental process on the part of the instigator who must have intended that the offense be committed. 2. Conspiracy, Section 46. This involves engaging in a conspiracy to commit an offense where an act or illegal omission takes place in pursuance of that conspiracy. It's about a shared agreement and subsequent action. 3. Intentional aid, Section 47. This refers to intentionally assisting by an act or illegal omission in the commission of an offense. The aid must be significant and intended to facilitate the crime.
Can you give us a quick example for each of those? Instigation, conspiracy, and intentional aid, just briefly.
Certainly. For instigation, imagine A tells B, who is known to be easily provoked, "You should really teach C a lesson. Break his window tonight." If B then breaks C's window, A has instigated the offense of mischief. The crucial element is A's active encouragement and intent. For conspiracy, let's say X and Y agree to jointly forge some documents to defraud a bank. As part of their plan, X buys the special paper, and Y arranges for a printer. Even before the forgery is complete, the agreement and the preparatory acts constitute abetment by conspiracy. For intentional aid, consider P holding open a back door for Q to enter a building with the knowledge that Q intends to commit theft inside. P is providing intentional aid.
So it covers encouraging, planning together, and actively helping.
Exactly. The nature of abetment is that it's a form of constructive or secondary liability, making those who enable a crime potentially culpable. Its scope is incredibly broad, applying to virtually all offenses under the BNS.
And again, while the BNS is new, How do we interpret these concepts of abetment? Do we look back at the old law, the IPC?
Absolutely. As with the general exceptions we just discussed, the rich jurisprudential history from the analogous sections of the repealed Indian Penal Code 1860 provides invaluable guidance. Sections 107 to 120 of the IPC covered abetment in extensive detail, and courts have developed a vast body of case law interpreting what constitutes instigation, conspiracy, and intentional aid. While the Sanhita provides the new legislative framework, the core tenets, interpretations, and practical applications of abetment that have been extensively developed over decades will continue to serve as the bedrock for understanding and applying these new provisions.
Wow, what an incredible deep dive into the BNS 2023 general exceptions and a crucial introduction to abetment. We've covered staggering amount, from legal duties and the nuances of good faith, to the absolute immunity for young children, the complexities of consent, the profound challenges of necessity, and the very boundaries of self-preservation.
It really underscores the sophistication of criminal law, doesn't it? These exceptions aren't mere loopholes. They're carefully crafted principles designed to ensure justice is meted out thoughtfully, balancing individual liberty with societal protection, and recognizing the many complex factors that can influence human conduct. Understanding these provisions is fundamental, not just for legal professionals, but for anyone who wishes to truly comprehend the spirit and letter of criminal justice.
Exactly. Knowing when an act isn't an offense, not because it's harmless, but because of deep underlying legal principles, truly changes your entire perspective on criminal liability. You now have a comprehensive mental map of these crucial defenses and the fundamental concepts of complicity.
And this map helps you see how the law tries to be fair and reasonable, even in the face of actions that cause harm. It asks profound questions about intent, capacity, and justifiable action, reflecting society's nuanced approach to accountability.
So here's a thought for you to carry forward. How do these deep-seated legal principles, some of which we've seen rooted in ancient maxims, continue to evolve and adapt to our modern world? And what new types of exceptions might future legal systems need to consider as society and technology advance, presenting new dilemmas that our current frameworks might not fully anticipate? Think about AI, cyber issues.
A fascinating question indeed, hinting at the dynamic nature of law itself, always striving to reflect societal values and technological realities, and constantly seeking to draw that fine line between culpability and exculpation. It's a conversation that will surely continue.
Thank you for joining us on this deep dive. Stay curious, stay informed, and we'll see you next time on The Deep Dive.